Hi, good afternoon, everyone. This is Team AmerBON. I'm the moderator for today because uh, Shara is busy. She's up to something. So, um, our speakers today is Edmund, Sinyu, and Mike. And today we will be talking about the new section that has just came into force on the 1st of June this year. It's the new corporate liability introduced by the Malaysian Anti-Corruption Commission Act, and it's going to bring a big impact on the companies and the partnerships. And our speakers today will deal with the questions and answer whatever questions that you have. So, without further ado, let's welcome Edmund to begin the session.
Thank you, Yiwei. Good to see you leading this chat. There are 5 main points that we need to bear in mind, and I've simplified it into these 5 sections for Section 17A of the MACC Act. The new provision came into force on the 1st of June 2020, and the first area or first point that needs to be borne in mind is that it applies to all commercial organizations. Commercial organizations are defined very widely. All companies that are in Malaysia and outside Malaysia, whether it is a company established under the Companies Act, whether it is a partnership, whether it is a business, all companies, foreign and local, are covered. That is the first point, meaning it is very wide and it would be very difficult to argue that if you were and not very difficult to argue that you would not be an organization if you have such an organizational setup in whatever legal form. So basically, this provision provides for the law to breach the corporate will. In a normal case, when you give money for a benefit as an individual, that we all know is corruption. For commercial organization, this new law, Section 17, breaches that corporate will, and you cannot hide behind the fact that you were acting on behalf of the company or for the company. So I think that's the first point that needs to be borne in mind. The second point is the definition of persons associated with the commercial organization. So the general thinking is that it deals with persons who are employees of the organization. It covers clerks, servants of the organizations. That is true. So if you are part of an organization, if you are part of a company and you give bribes for contracts, you definitely will be liable for corrupt practice. But this provision is even wider because it covers associated persons who are not necessarily persons employed in the company. So it includes outsourced agents. It includes third parties that perform services for the company or on behalf of the company. It can be office delivery man, or it can be a recruitment agent, or it can be a distribution agent, it can be a joint venture partner, it can be a subsidiary. So it does not only limit persons giving the bribes to people who are employed by your company, but it includes persons who are also working in partnership with your company. Third parties, and these are what we normally call in business and human rights part of the larger supply chain. So that is the second point. It covers very general, all companies. Number 2, it covers everyone working in collaboration, in cooperation with your company. The third point that the new provision provides for is the defense of the company or your commercial organization if you have been found to or being investigated for giving bribes. The one question the investigators, MACC, will ask is whether your company has had adequate procedures to ensure bribery doesn't happen or to minimize the risk of bribery. This is a defense for your organization. If you are not able to show that you have these adequate procedures, you won't have no defense. Meaning, if somebody, whether you know or you don't know, has given a bribe to obtain a contract for your company, to obtain a benefit for your company, you would have been, or you are liable for corrupt practice as a company unless you can show that you have taken these adequate procedures. So then the question becomes, and this is where compliance and law comes in, but in a very practical way, what do adequate procedures mean? And when you ask lawyers or you ask consultants what type of procedures are necessary, what type of structures, mechanisms are necessary, there will be a divergence of view. This is where you will really have to be as logical and as careful or cautious as possible. So you have some guidelines that have been promulgated by government called the Guidelines on Adequate Procedures under Section 17A. And these guidelines provide for certain areas of accountability and safeguard mechanisms. I will explain that in my fifth point, but just for the third point, this is where I think a lot of companies trip up, because for SMEs and small companies, it's going to be time consuming and it's going to be expensive to put in place such procedures. You would need some sort of an expert. You would need a monitoring and evaluation mechanism. You would need a code of conduct. You would need good oversight good oversight sort of radar on your employees as well as on your supply chain. And increasingly, when we talk about business and human rights and sustainability practices, a lot of these governance, accountability, and anti-bribery measures become important as indicators to whether your company is a sustainable company that does not condone corruption and has safeguards in place to investigate. Some sustainability indexes actually even compile or require that companies, especially public listed companies with a huge market cap, inform or report the number of complaints of corruption, as well as to ensure that they have mechanisms like a code of conduct in place where if there are complaints of corruption or whistleblowing issues on corruption, those issues should be brought up to management as quickly as possible. So adequate procedures is partly subjective, but is also partly objective given how the government has already come up with guidelines. And especially for big companies, our advice as lawyers would be to make sure that you look at those guidelines properly. You make sure that the supply chain and all your mechanisms comply with, in a practical way, with those guidelines. This is where regulatory and compliance work is necessary to make sure that you insulate yourself from charges of corruption. That is the third point. The fourth point is that if the company is found to be liable for corrupt practices, it then the law then has a deeming provision where any director, controller, officer, partner, or person concerned with the affairs of the company will be also liable. There is a deeming provision. So normally, this deeming provision would apply to senior management or even the chief executive officer. Whether you know that corruption takes place or whether you do not know corruption takes place. That's why the point about my third point about having adequate measures is important, because if something happens, then there should be a red flag immediately for higher management to know. So this fourth point is, first, if the company is liable, if the company has been found to have committed corrupt practices. The second impact is that directors, controllers, senior management will be deemed to have also committed offence. Meaning, in theory, MACC can charge, one, the company. So it's public prosecutor against company A. Two, the MACC can charge the director personally or the senior manager personally, PP against ABC. Or you can find charges of, one against the company and two against the director personally, heard together. So in practice, the law allows for this, and the law allows for personal liability to be imposed on senior management and the directors. Because in the normal case, if you only charge the company is a fiction, a legal fiction. Nobody can go to jail. You can, at most, like for example, open burning. Companies that have been charged for open burning under Environmental Quality Act, you can only fine them. Companies that fail or there are fatal accidents in their factories, you can only charge them, the most they can get is a fine. You cannot send the director to jail unless you can show that the person has been personally liable. And so this new law makes it easier for the authorities to go after senior management as a person, and the person can go to jail. The penalty for this is 10 times the gratification sum, or 1 million, whichever is the higher, or prison of 20 years, or both. So it's quite a serious offense, and the deeming provision is something which I think will make a lot of senior managers, a lot of, even not even senior managers, even those managers and operatives down the line in companies to wake up and be careful about what their employees do and what third parties do on their behalf. But the silver lining, of course, is that where there is a deeming provision, then if the director is charged or senior manager is charged, then the director or senior manager has a defense under statute to show, and the burden is on him because there's already a deeming provision, meaning they presume that the director also committed it. So what the director has to do when he goes to court is that the director has to show two things. He has to show that this corrupt practice took place without his consent or took place without his agreement. That's one. But number two, he has also to show that he and the company had taken all necessary steps, what is called due diligence, to ensure that this corrupt practice will not or should not happen. So this is where the confusion comes, because is this due diligence, is this second limb? You need to show both. You need to show that there's no consent, no connivance, and due diligence. But is this second limb also related to the first adequate procedures limb regarding the company, the one that I mentioned in point 3? So if the director shows that the company had taken these adequate procedures, would that be sufficient due diligence? We can talk about that a bit later, but In Malaysia, of course, because this is a new provision, we don't have cases, so we have to look at other countries. That's the fourth point. The fifth point is what government has neatly called T.R.U.S.T, T-R-U-S-T. Those are the guidelines that Yue showed just now. Trusts are the 5 different things that MACC has recommended strongly to be done by companies and to be done by commercial organizations. And in fact, it's good practice to do it anyway. In business and human rights, that's something that you need to make sure you have, especially if you want to get to the sustainability indexes. But in Malaysia now, the recommendation seems to be focused on these 5 areas. Of course, from a good practice standpoint, these are not exhaustive, but these 5 areas are generally what happens or what we see in when we advise our clients. So one is top level commitment, basically policy statement to get companies to say publicly on their website or on their annual reports or in how they manage, when they manage the staff and other suppliers, there must be a commitment of zero tolerance of corrupt practices. After the second one, so that's T, and then R is risk assessment. Risk assessment basically is another way of saying due diligence. And due diligence is not only the due diligence that we know of when there is a merger or acquisition or when you buy a company, but it's due diligence that relates to accountability measures that also relate to good business practices. And of course, some people now say human rights and sustainability. So risk assessment mechanisms are especially important for big companies where you have so much supply chain, you have so many relationships with other actors. Then U is undertake control measures, which are internal mechanisms again. S is to have systematic review, systematic monitoring and evaluation. And that's why I mentioned you need to either have an oversight committee or you have an oversight personnel that looks at the procedures and the processes. And of course, T is the last, training and communication. So T.R.U.S.T are these guidelines. How those guidelines are going to be implemented, these recommendations are very wide. This is where you would probably need experts to come in to have a look at your operations, to say, okay, this is where we need to improve, this is where we need to add to the handbook, this is where we need to add to training, this is where we need to make sure payments, we reduce payments by cash, for example, make sure everything is done properly, computerized. So there are a lot of different areas depending on your line of business. The big challenge, I think, for big businesses would be the supply chain. So how do you deal with your lower level employee, your street level employee that deals with third parties, that deals with agents, that deals with governments? And I think that's where a lot of the petty, smaller corruption happens, but it's still an offense. So those are the very quickly, those 5 quick points that I wanted to open up with, and I'll hand it back to you. And if there are any questions, we can take questions later. Thank you, Yue.
Thank you, Edmund. That's very informative. Yeah, so companies and partnerships in Malaysia, or whether you're in Malaysia or you are a foreign company, if you have business in Malaysia, be careful. You have to have these adequate procedures in your system in order to avoid any future liability, because it covers very wide area, and even if any third party or your employee, if they are doing some corruption act, you would be liable as well. So thank you, Edmund, for the explanation. Next on, we have seen you. The legislation actually, this new section was made based on the Bribery Act 2010 in the UK, and CU will talk about it and also compare our Malaysian legislation and the Bribery Act, and to give us an insight of how how both of them work together. Sunil, please.
Actually, before I go into that, right, I was reading that section 17A again. I think there's a loophole, but should I mention it here? Because we can probably build on that. I mean, should I mention it here? I think there's a loophole, it's quite glaring. Josh, how?
Yeah, of course you can mention it.
I should mention it. Oh, okay. So if you look at 17A, right, and you look at the definition of a commercial organization, 17A sub 8, bracket 8, it means a company or a partnership, effectively, or LLP. And if you look at how it's worded under sub 1, commercial organization commits an offence if a person associated with the commercial organization corruptly agrees, blah, 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 to obtain or retain business for the commercial organization. And sub B is also the same thing, for the commercial organization. So it refers to the same commercial organization. What happens when one commercial organization gives or agrees to give a promise or offers to any person any gratification for another commercial organization? That is not covered under 17A. So assuming that you have a subsidiary and whoever is at the holding level commits the bribery on behalf of or for that subsidiary, and he's not somebody who he's not a, where is it, officer. Where's the definition of person associated? Yes, 6. He's not a director, partner, or employee of the commercial organization, or he is a person who performs services for or on behalf of the commercial organization. So it doesn't, sub 6, if you look at it, it seems to only cover effectively officers for the same commercial organization, and probably a third-party contractor, a person who performs services for or on behalf of. So what happens when you have, one CO, commercial organization, bribing for another? So, this is quite a glaring loophole, and we shouldn't capitalize on this because it's wrong to bribe. It's an offense to bribe. So please don't do that. Someone should tell MACC about this, or the legislature. But anyway, I'm going to talk about UK. So in UK, right, it's effectively the same test. So instead of going through the law again, which can be quite dry, I'm going to talk about 2 cases. So the first case is a construction company, and the second case is a very famous company, very famous car company. Is it a car company? I think they only do cars, right? Never mind. Okay, the first on the construction company. This case of Crown against Sweet Group PLC. So what happened here was that an employee in this subsidiary of Sweet Group PLC, in Dubai, he bribed a senior executive of another company, development company, to secure a building contract of a hotel in Abu Dhabi. So there was a trial, and the judge, he explained that there is a failure in the organization's system, because the bribery, the act of bribing, it had taken place over a long period of time. So a total of 2.25 million pounds in fine was ordered. The company or the commercial organization, I think we have to use a statutory term. They were unable to rely on the statutory defense like ours because there was simply no adequate procedures in place. And what was perhaps pertinent here is that an accounting firm, I think their auditor, they produce a number of reports or red flags calling for better internal governance. But this was not acted upon. So I think what the takeaway that we can get from this case is number one, obviously it's important to have adequate procedures in place. Number two, the position in UK law might be a bit different because I don't know how a subsidiary was eventually, the act of bribery took place in a subsidiary, but it's the holding company that was convicted. So I'm not sure whether there's a difference there in UK law and in our 17A. Because from the reading of 17A, it seems to be a bit different. Maybe the judiciary there interpret it a bit differently. And the second takeaway is that audit firms would now have to look into whether companies would have adequate procedures as part of their auditing standard. So I think that's something that will have to change. And where certain flags are being raised that there's inadequate procedures, inadequate standards, it's going to be a liability for the company if the company do not act on it. So that's the first case. The second case is Rolls-Royce. I think Rolls-Royce is a car company, but I think they manufacture engine as well. Well, of course, car companies, they would naturally manufacture engines. So what happened here was Rolls-Royce was fined 600 million pounds because two of their subsidiaries, they were committing bribery, fraud, and corruption over a period of years. What happened here was there were agreements that were discovered, and these agreements were agreements to make corrupt payments to agents in relation to some, I think, airplane engine, over a period of 17 years. So that if it happened over a period of 17 years, quite clearly can be seen as being part of the practice of the company. And as a result of that, they were found to be liable, and quite clearly that if you have done it over 17 years, even if you have adequate procedures in place, you may not have acted on these adequate procedures. So, I would even though you can say that it is a statutory defense to have an adequate procedure, but if you fail to act on this adequate procedure, it cannot be said that that procedure is indeed adequate. It's perhaps adequate on paper, but it may not be adequate in practice. Or you can even say that it's probably not a procedure at all, if it's there and no one acts on it. What's interesting about the Rolls-Royce case is also the fact that it was found that there was a failure to prevent employees to provide inducement in China and, surprise, surprise, Malaysia between 2010 and 2013. So it seems to be part of this trend of news where every time large-scale corruption takes place, it would either be linked or it would have occur in Malaysia, or we have something to do with it. So yeah, we are always making news for all the wrong reasons. That's pretty much it on UK. Yeah, pass it back to you, Yue.
Thanks, Yu. That's very informative as well. Next up, we have Michael. So there's actually an act which is quite similar to Section 17A. It provides, in particular, Section 50, 52 and 55, which provides for the liability of the director, whether they act jointly or not, and there will be a defense for them to rely on. It's very similar. And Mike will talk about that in light of the businesses opening up and also the following the SOP in relation to the COVID. Michael, please. Thank you.
Hi. Thanks, Yue. The act that Yue was talking about is actually the Occupational Safety and Health Act, and also the infectious disease, the prevention and control of infectious disease regulations. Right, sectors open up their businesses to operate at full capacity after this whole MCO is over in its rehabilitation stage. I think it is very important that the SOPs are being complied with, because if there are SOPs are not complied with, they run a risk of companies run the risk of getting charged under the regulations I mentioned earlier, or under the Occupational Safety and Health Act, because under these two acts, especially under the regulations I mentioned earlier, there is a need to comply with the orders given by the DG and the orders given by DG and the Ministry of Health. So that there has to be such compliance with the SOPs. Failing to comply with those SOPs, and if you don't comply, there is a risk to the employees, then it will also fall within the purview of the Occupational Health and Safety Act. So what happens is, when there's such a failure to comply with the SOP, under both the regulation and also the Act, companies, like Edmund said earlier, companies can be charged for the offence. And the same thing, directors and also the directors of the company can also be severally charged, that means separately charged, or charged together with the with the company. So yeah, so I think it's very, very important to bear in mind that as we are talking about offences relating to companies, we need to also look into ensuring that companies follow the SOPs moving forward also. And also, on top of ensuring that there is there's anti-corruption, then not only that the company must prevent anti-corruption, the company must also ensure the safety and health of its employers. So it now covers, the liability is not just with the company, but also can also be with the directors. So the defense is also the same, where for example, under the regulations I mentioned earlier, it's whether the defense is whether whether the employer had, whether the director, whether the offence is committed within his knowledge, consent, or connivance. So, and whether he took reasonable precautions and had exercised due diligence to prevent the commission of the offence. So yeah, it's the same similar defense. So yeah, I think it's important for corporations and directors to take into account moving forward, these provisions moving forward. Yeah, so thanks.
Thank you, Michael. We have a few questions, a few comments from the viewers. I'm going to ask them. The first question I would ask Mike. It's from Rachel. Would it be prudent to make employees to sign a pledge for anti-corruption and anti-bribery? Mike, can you answer this, please? I think you have muted.
Whether it be prudent to make employees to sign a pledge for anti-corruption. I think to sign a pledge for anti-corruption and anti-bribery, yeah, yeah, you can, but it's just a first step. It's just a first step, and it's one of the control measures that you can put in. But then at the end of the day, it is just merely a pledge. But what we need to look into is the details and specifics of the mechanisms that will be put in place, uh whether there are adequate precautions in place or not. So yeah, it is just, I think, to me, I think it's just a first step.
Thank you, Mike. Next up, we have a second question. I'm going to ask Josh about this. It's from Jajin. Can the employee who accepted the bribery being sued with the company together with the senior manager and the director under Section 17A, or the PP can take other action against that employee? How about whether the company and the senior manager can sue the employee, perhaps damage the reputation of the company as the effect to accept the bribery? Yep, Josh, please.
Hi, thanks Jajin for the question. I think first and foremost we must recognize the difference between a civil and criminal case. So when we talk about bribery, especially under the Malaysian Anti-Corruption Commission Act, these offences are criminal in nature. So the action will be taken, or the prosecution will be taken by the public prosecutor, by the government instead of the company itself. But having said that, the company can take disciplinary actions against that employee. It's actually stated in the guidelines that companies are allowed to have their own disciplinary proceedings for employees who flout the anti-corruption compliance program or system framework which they have in place in that company. So I hope that answers your question. But I want to add to what Edmund and Mike said about the deeming provision. I think this is quite an important point, and in fact, it's quite an interesting point because a few years ago, a similar provision in the Securities Industries Act was challenged, and it went all the way up to the federal court on the grounds that it's unconstitutional because it breaches the separation of powers and it's inconsistent with the presumption of innocence. In that case, the case is Gan Bun Leong. So in that case, the federal court said no, the deeming provision is constitutional. But my personal view is there must be a difference between serious offences. What's that noise? So sorry. So as I was saying, there must be a difference between serious offences and mere regulatory offences. So usually for regulatory offences, like Mike mentioned, OSHA, maybe Food Act, OSHA is the Occupational Safety and Health Act, the Food Act, the Environmental Quality Act. You have similar deeming provisions, but we must look at the penalty. The penalty in those cases are usually, I think, less. I can safely say it's less than 10 years. But for this particular provision, it's actually 20 years. And I think it's in view of how severe the punishment is, making or having a deeming provision to attribute culpability or liability to the directors is actually unconstitutional and unfair. Even say, for example, a manslaughter offence or culpable homicide in Malaysia. Culpable homicide not amounting to murder. Section 304A, small a, it also carries an imprisonment term of 20 years. And in that kind of offence, under 204A, the mens rea element, the element of intention or knowledge is still required to be proven by the prosecution. So I don't see what's the difference in this case for the prosecution needing to prove knowledge on the part of the directors or any officers of that company, whether they have authorized or permitted or they knew that this corruption were taking place. So of course there's a standing federal court decision stating that it's unconstitutional, but I think it's worth relooking at this point. Thank you.
Thank you, Josh. We have the next question, and I'm going to ask Edmund about this. It's from Spring. Are third-party integrity pledges required? There's a flurry of people insisting on signing this third-party integrity pledge when there's no real relationship between the parties that fall under the purview of associated persons. Can Edmund answer this, please?
Yeah, thank you very much. Of course, we will always support these type of initiatives to get people to sign on to things. I'm not sure what context you have mentioned this with, but in business and human rights, what we have been advising is that at least with third-party suppliers that are outside our organization, let's not talk about inside the organization. Inside the organization is very clear. You need a code of conduct, you need mechanisms in place, you need whistleblower protection, you need all those things that's inside. So whatever pledge you sign, has to be operationalized either through a staff handbook or through actual mechanisms in the office. If it's outside the office, so when you say third-party integrity pledges, I would suspect, can I get my third-party vendor or can I get my agent to sign these pledges? That's fine. You can get them to sign it, but that is not necessarily enough because that only reaches a level of a written commitment. Have you done your supply chain checks? Have you done and looked at your client customer base, your agent base? Have you done your audit on how they operate? Do they themselves have their own mechanisms that will stop or be able to detect corruption? So this was the thing that I didn't want to go into because these were the practical tips that I was talking a bit about trust. I hear, since it's a very good question, I intend to go on this a little bit if you allow me to. So there are a lot of situations where when you buy over the company or when you merge with a company, you always do due diligence, right? Here is the same, or in fact, it needs to be a more robust. When you talk about due diligence within a company and a situation where you are buying over another company or where you are going to merge with another company, because bear in mind, when you merge and you are a successor to another company, these liabilities do not fall away. If corrupt practices still continue or still have been continuing, you are still liable. So in practical terms, what it means is at least 5 things. 1, legal, accounting, compliance review of sales and financial data, customer contracts, third-party and distributorship agreements, and consultancy agreements. I think everybody likes to use the word consultants, right? So consultancy agreements have always been the name for a lot of these corrupt practices. So that's 1, compliance review of these information, not only of yourself, but of third parties. Number 2, there needs to be a risk-based analysis of the customer base, as I mentioned, KYC. So AMLA already has these requirements in place. Bank Negara has guidelines for it, and we need to follow it, even as lawyers. We need to know our client. We need to get their passport. We need to get IC. We need to check where the money is coming from. Is it money that it comes from legal or illegal activities? Number 3, we need to perform forensic audits when necessary, where necessary, especially for large transactions that are questionable. So if you look at the GL or you look at the profit and loss and you look at the balance sheet and there are large transactions going in and out, you need to look at the forensic audits. Of course, if those things are on paper, but we know corruption is not always on paper, yet these are mechanisms that you take place, especially when you're taking over a company. Number 4, you need to really discuss your anti-corruption measures with your staff and, of course, the training. But these are handbooks and code of conduct stuff that needs to be discussed consistently, holistically in toolbox meetings with everyone, right down to the lower level employee. And number 5, I think I mentioned this about anti-corruption compliance measures, those mechanisms that the government has already suggested, but also there will be more in terms of auditing and in terms of due diligence. Yeah, so to answer your question, third-party integrity pledges, whether you want to do it or not, may signify a little bit, but in the scale of things, it may be only 3% of the 100% of things that you need to do. Because we know that in business and human rights, the supply chain, the third-party people outside the companies are the most difficult to control. So how are we going to do that? I think around the world, we're still trying to negotiate that kind of approach. How do we make them comply? How do we make sure they comply? And especially for those vendors or those suppliers that really have a foothold and monopoly in what they do, right? It's really difficult just to say, I don't want to use you anymore. So those are the challenges that really need to be discussed. And those are things that we have been advising clients on to try and get things better, get things moving. But also it's a lot of negotiation and a lot of awareness building with the vendors and with the third-party suppliers. So I hope that answers the question. Don't look at the law. In essence, don't look at the law, because based on your question, don't look at the law as, oh, associated person, so I just get them to sign it or I don't get them to sign it. Let's see who is an associated person. Basically, to be cautious as a lawyer, I will tell you, assume everybody that supplies to your business operations is an associated person. And whether it's in your company, whether it's outside the company, or whether it's a third party. So I hope that answers the question. You got a very nice name, Spring Glass. Thank you for the question.
Thank you, Edmund. Yeah, so everyone has to really look at the overall of who you are going to deal with, just in case, because this penalty is really severe. Okay, next up, we have the other question. So we know that Section 17A deals with the situation where an associated person in your company gives bribe to the other person. But what about receiving? What about when your employee or an associated person receives bribe from another party? Can Sinyu answer this, please?
I think this question is better answered by Josh, because he recently just did a case where it's a case of receiving. So, and that fella just got acquitted. So maybe he wants to answer the question instead.
Very simply, the answer is don't worry. Those who receive the bribes action can still be taken on them, but the offence is actually under either Section 16 or Section 17 of the Act. So 17A only covers the corporate liability provision, but for those individuals, for employees who offers or receives, it will fall under 16 or 17.
Okay, thanks, Joshua. We have the same question.
Just to that question also, just to that answer, I think Mabel is right. 17A doesn't deal with receiving. It only deals with giving. Yeah, that's right. So it only deals with giving based on the wording compared to the other provisions at MACC. But I think what Joshua is saying, that you look at other provisions in regard to receiving. But 17A per se for the corporate liability only imposes the legal obligation on that sort of deeming provision for companies that are paying for the bribe.
Thanks, Edmund. We have another question from the same person. The question is, practically, should dormant companies also adopt adequate procedures? Can I direct this question to Sinyu?
Well, as a matter of best practice, they should. But if it's dormant, it's not carrying out any activities, right? So where would the act of giving occur? So even if you got procedure, there's no one there. It's kind of pointless, isn't it? I mean, it's like as though as you're putting the cart before the horse, if I can use that idiom, but well, that's not really a right idiom. I just don't think that it's necessary for dormant companies to adopt adequate procedures unless you're going to go active again someday. Yeah, but otherwise, no, it's not practical.
Yeah, practically it shouldn't also cover, I think, sole proprietorship or like a single man entity or enterprise, because I think in
It
those
doesn't.
cases,
I don't think it. I don't think it covers sole props, lah. Yeah, it doesn't cover sole prop.
yeah,
You look at the definition. Yeah, and sole prop would be personally liable anyway, right?
Yeah, you don't need to cover sole prop
Yeah.
because
So
sole
there's
prop
no
is
like
individual.
separate legal entity. There's no corporate will to pierce, to lift. Yeah.
We have a follow-up question from Mabel as well. Or the extent of this practice on small cost or on small companies or investment holding companies. Maybe Sin-Yu can give your opinion on this.
Oh, the way I see it is that you really got to look at the nature of your business. If you can confidently say that your business will not put you in any position or any of your officers' position to give or be accused of giving bribes, then as a matter of practicality, you may decide that okay, I do not need this adequate procedure, because Section 17A doesn't make every company. It doesn't make it mandatory that every company adopts an adequate procedure. I think it's necessary in companies where there's a likelihood of their employees doing something which they may not know about, or the employees do not tell them everything. And this would normally be in perhaps medium-sized companies or bigger companies. But if you're small, and you're confident that such an occurrence is not likely to occur, then yeah, I can understand the refusal to adopt adequate procedure. But that being said, I would think that in excess of caution, you should have it, because once this thing takes flight, where guidebooks are quite easily available, or it's available at a commercial rate, then there's really no harm of you getting a lawyer to draft it for you. It's still new, so we're all excited about this.
But I think it should, as a matter of caution, it should, because what happens when the definition of associated persons, if you look at the definition, and your example just now seen you about a subsidiary as well, in America and also in England, although the word is commercial organization here, the way that the investigators have done it and the prosecutors have done it is that they have to look at the factual scenario of that case. So sometimes the parent company would have paid the money to the third party to retain the third party innocently, but the deal is done with the subsidiary. Still, the parent company would have been liable, although the relationship actually was with the subsidiary and the third party. So you never know. The point is you never know, and that's why from a lawyer's perspective, I would always want to say, just be cautious if you have transactions going up and down, and high transactions. You just apply it across the board. Look at a holding company, even with the subsidiaries as one company, because the way it's drafted is so wide. The law is so wide, and you don't want to be going to court and then facing a charge and then having to defend and explain. Maybe this situation didn't happen. You don't want that, maybe. So I think that's what the government is saying. The government is trying to get everybody to put in some of these procedures in place. And I've seen a lot of cases like that when we do the business and human rights reviews and the audits. Is actually, there are many loopholes, and I know why they are trying to, what they are trying to get at.
Yeah, and it's not just limited to subsidiaries, because if you look at the definition of person associated with the commercial organization, right, under 6, it includes a person who performs services for and on behalf of the commercial organization. So that includes your suppliers as well. So even though you are a small or investment holding company, and you have suppliers which you may not confidently or adequately control, it's definitely worth it to have adequate procedures in place, even though you're small. So it's not merely a question of size. It's also you should take into account the nature of your business as well.
Okay. Thanks, Inu and Edmund. I'll direct the next question to Edmund. It's from Rachel. Should there be zero gift policy, or what if the company has a gift policy that allows gifts not more than 100 ringgit? Is that condonation?
Actually, that's a very good question. When Sinu, Joshua, and we wrote 2 articles in 2014, 2015, we had to dig so difficult. I think it's now public, but and we can share it on our website. I have to dig out those articles. One, there is actually a allowable gift policy in government. There's actually some guidelines that allow, I can't remember offhand now, but there are actually some gift policies in government that allow for certain gifts up to a certain value, which government can keep. The value is not very high, but actually government servants can actually keep it. So similarly, if you ask me, different countries have different type of policies and what value you place. So long as your company or your organization has in place these type of specified guidelines, and you cannot say, oh, a gift of 1 million ringgit is allowed. We're talking about Hari Raya cookies and stuff like that, which if I would say, let's follow the government policy on payments of these things, it's not really payments, actually in kind. Or even, for example, if you go out and speak and you spend time traveling to speak and somebody gives you some money for time, 50 ringgit or 100 ringgit, so long as 2 things happen. One, it needs to be in the procedures and the guidelines. It needs to be written so the employees clearly know what can be accepted, what cannot be accepted. 2, internally as well, the figure cannot be so wide or so large, and there must be a certain reporting structure, meaning sometimes directors or sometimes people who have conflict of interest receive gifts that needs to be reported. So sometimes in my organization last time, what we would do is where gifts come, I would just give it back to the partners, tell the partners, or in fact, if cookies come, I wouldn't even eat it. What I'll do is I'll just give it to all the staff and say, look, this was from somebody, and this is for everybody to share, and just let everybody know. So that makes sure that everybody knows about it, and there's no special treatment, and people know that whatever you are giving, doesn't benefit you personally. So there must be that standard operating procedures. It must be written, meaning, for example, the code of conduct, if that's the corporate language. And also a lot of times, depending on the value of it, it should be reported or be made public.
Thanks, Edmund. We have time for one last question. It's from Lu Zong. In Crown against Skansen in the UK, the decision seemed to suggest that the UK Bribery Act was not retrospective. Simply put, the offence was committed in 2013. In 2014, the company established certain adequate procedures. Sometime after that, the company was charged under the Bribery Act, and the court only considered the procedures set in place at the moment of the offence. If this is true in Malaysia as well, and a company is charged under Section 17A for an offence committed prior to the company. So I think the question not finished yet, but can Sinu answer this, please? No.
Is it true in Malaysia?
I'm not sure whether this is a question or a statement. It looks like a statement.
No, what basically I think what Zhu Hong is asking is whether it is retrospective. So in the situation, I touched on it a little bit just now. These situations will happen normally where there are successor companies that join together. So if there's one company that has been committing bribery and then it is sold on to another company or that company takes over, the question is, do the current directors of the new company that have taken over these practices, are they going to be liable for that kind of corruption? So in America, a lot of the scenarios like this have happened where there has been a buyout or sellout. So the first principle is very clear. If it is not an offense at the time of the commission of the offense, if the law doesn't provide for the offense, then it's not an offense. But if the practices of the old company continue under your directorship or still with your knowledge as of 1st June 2020, then yes. So simply put, it is not retrospective because you cannot create a retrospective offense. But if on the facts of it, past 1st of June, which we are already past a few days, 9 days, 10 days, you need to make sure you go in, do your due diligence, as I said. You need to make sure you take all the 5 steps, the trust steps. You need to make sure, and if you do not make sure, and it still continues under your directorship and under your leadership, and your third parties are still doing it, then yes, it's an offense. So that situation also covers a company where there's not bought over or there's no JV. The company continues. It is your company. So to answer your question, I think as I understand it, one, you cannot create a backdated offense, but as of 1st June, you need to put in these procedures. And if the corruption happens 1st June onwards, then if you don't have those procedures, you may be liable. I hope that answers the question.
Actually, there's some technical problems just now because the question is a bit long, so it couldn't display on the screen. So this part when which I'm displaying, the last part of the question is, if a company is charged under Section 17A for an offence committed prior to the company establishing adequate procedure, how else can the company defend themselves? Edmund, do you have any, or Joshua?
Joshua, I think that's what I said, right? Joshua, am I correct? You cannot have an offence that's backdated. 17A only came into first as of the 1st of June.
Yeah, strictly speaking, for criminal offence, you more often than not they cannot be retrospective. But I think actually if we look at 17A, right, and I actually thought of a situation, and I myself am not sure whether it will be covered under 17A. For example, this group of people colluding to engage in some corrupt activity before starting the company or starting the business. So they have probably put in place certain actions to probably obtain business for that particular company, but they haven't actually established that company. But I think it may be wide enough to cover, but if I'm the defense lawyer, of course I would say no lah.
Thanks, Josh. Okay, one last question from the comments because we are a bit over time. It's from Joanne. I'm going to direct this question to Sinew. The MACC Act is modelled upon the UK Bribery Act. However, the UK Bribery Act includes subsidiary as an associated person, but this is specifically not included in the MACC Act. Although a subsidiary may still fall under the category of persons who perform services on behalf of the commercial organisation, this exclusion may essentially mean that the act of subsidiary, which is unconnected with the commercial organisation, is outside the scope of the MACC Act. What's your view on this, Sinew?
Yeah, so this was what I mentioned at the very beginning.
This is your loophole.
Yeah, it's not just the act of subsidiaries outside of the scope. The act of the parent company could be outside of the scope, or the act of a third-party company could be outside of the scope. So the corporate liability seems to be confined within that organization. I don't disagree with you, or I don't disagree with myself. So Yeah.
So I
Anything
think
else that-
can I just add to that? I don't think the law is such where it demarcates subsidiary and not subsidiary and not a subsidiary. As I said just now, associated persons is large enough. Sinu has also mentioned it. Associated persons includes people that does your service, works on your behalf, contracts, pay certain money so that there is a benefit. And if the benefit goes to the parent company, and the parent company themselves know about this. So the example in under the Foreign Corrupt Practices Act in America, albeit slightly different, right? While the subsidiary paid the bribes, but the parent company was the one that was controlling the subsidiary. One. Number two, the subsidiary's president was reporting to the parent company's board. Three, the lawyers of the parent company approved these payments to the third party, not knowing that they were bribes. And then the fourth one, there was insufficient due diligence shown. That parent company was still liable for the subsidiary. Of course, the law is slightly different, but I would argue, if I was the prosecutor, that, and it is wide enough to cover the associated person, whether it's subsidiary, whether it's parent, whether it's JV partner, whatever. So when I started out, I was very clear, we need to be very careful because the way it's worded, you can argue it anyway because it's so wide. And when it's not tested at the moment, we are not sure. That's why as lawyers, we would want to advise to be careful. Yeah.
So that's yeah. So this view by Joanne, it would be a view that or it would be a position that a defense lawyer would take. So if there's another view, okay, if you look at 17A1, all right, what exactly does obtain or retain business for the commercial organization mean? So it could be a situation where, like Edmund said, the parent company does the act of bribery and the contract is given to a subsidiary. That, I think, 17A1, I think, would be wide enough to mean that the contract that was awarded to the subsidiary is a business for the commercial organization, being the parent company. So, you know, you are reading it wider, and you know, in a way you could even be stretching the ordinary meaning of 17A1, but yeah, this needs to be tested lah. Defense lawyers, you know, we would take a different view, the prosecutors would take a different view. So, you know, if you're unsure, please give us a call. That's not soliciting, right? Okay, better stop talking.
Thank you, Sinu. Okay, since it's time's up, so like we have to stop talking also. Okay, next up, next week, Tuesday, same time, 12 p.m., we will have another Legal Aid Chit Chat session. Check out our Facebook page or Twitter page. We will post about what topic we are going to talk about in due time. Thanks everyone for tuning in, and thank you to our speakers. See you next week. Bye.